topic regarding the second medical law and ethics. As we have discussed regarding the basic definition, forensic medicine, it is a medical aspects of law, while in the case of medical jurisprudence, it is a legal aspects of medicine. Forensic medicine, application of medical and paramedical knowledge to aid in the administration of justice. Medical jurisprudence, legal responsibility, particularly to those arising from the physician-patient relationship. So it is a legal responsibility of the treating doctor, such as negligence, consent. So these are the various issues in which there is a legal responsibility of the treating doctor is arising. Ethics, it is a moral principle. Every business has a moral principle. So in the case of medical profession, we have ethics, that moral principle which should guide the members of medical profession to deal with each other, to deal with the patient, and to deal with the state. We have our state responsibility towards the state also. We have responsibility over the patients also. We have the responsibility towards our another colleague or also. So we are discussing today regarding the medical law and the ethics. What students should learn after getting the lecture, that at the end of topic, the student will learn why this topic is necessary. Basic about ethics. Another basic definition regarding the ethics, it is a etiquette. So it is a law of courtesy that is observed between the members of medical profession. Bioethics, there are four main principles in the Indian Medical Council and the State Medical Council. Now again, it will be converted into the National Medical Commission. But before finalization of the schedule of the National Medical Commission, we are dealing with the Medical Council. So, basic function of the Indian Medical Council as well as basic function regarding the State Medical Council. Warning notice, what is that? Penal erasure, professional death sentence, Hippocratic oath, these are all, we will get the clear information about these topics. What is ethics? It is nothing but less than the reverence for the life. Why study of ethics is essential? So if we are not knowing the basic legal concept, then there will be young medical doctor, means recently passed out doctor, it will be having if they have no such any basic legal knowledge, so there will be a chance that negligence behavior occur, failure to discharge compulsory duty towards the patient and the state, and amounting, it will be lead to infamous conduct, or the patient doctor may face the negligence charges. Members of the general public are increasingly aware of their rights due from a doctor, questioning the legality of the issue. Doctors should also know who are the authority that proposing the rules and what penalty that will be followed when these rules are not to be regulated by the doctor. And what penalty one is likely to be punished within the event of break of them. So, violence against the doctor, as we are knowing that assault on the doctor are increasing day by day. There is a false charges of negligence too, and this will lead to defame our image in the public. But to better overcome this, we can have a specific legal knowledge, and by applying this legal knowledge, we somehow lessen the chances of violence against the doctor. These are the situation. When this assault on the doctor is increasing, there may be a chance that in the case of future doctor wear the helmet. But there may be this will be not happen if the doctor follow the basic legal principle, basic ethics principle, as well as applying the basic legal knowledge in the treating of the patient. What is the need to learn? That is the ethical, what we have to study, whether ethical, whether legal. But the case of proper, we have to study both ethics as well as proper legal knowledge. Legal knowledge that is applicable to the medical practice. Ethics, it is a science of moral value. It is a moral principle which should guide the members of medical profession in their dealing with each other, dealing with the patient, dealing with the state. The principal objectivity of medical profession is we have to render the service to the humanity with full respect for the dignity of human being. Every doctor, whatever his or her specialty, has to discharge medico-legal responsibility and to solve medico-legal problem from the first day of his or her practice. Everything doctor does in the practice of medicine, it is again governed by the legal system. So ethics will be, there will be value, that ethics will be applied in the case of research. It is a moral principle. We have to do ethical practice. There is a rule of conduct and rules and regulation. Ethics, it is a term that will be derived from the term, it is known as ethikos. The ethikos, that is known as rule of conduct that governs the natural disposition in the human being. Deal with the moral principle which should guide the members of medical profession in their dealing with each other, with the patient and with the state. The word moral, Latin term, it will be known as more. And the concerning more, it will be known as our behavior. The behavior may be good or the bad. So goodness or badness of the human character or the behavior, it will be defined known as more. And this more, that will be known as moral principle. So moral will be our sexual, social behavior, and ethics, it is our professional behavior. The contemporary construction of the bioethics will be first well formulated in the United States in the 1970 by the statement of four main principles. There is a autonomy, means whatever the patient has a characteristic that it should be patient's self-autonomy. Again, we have the provide the treatment for the benefices of the patient. We are not providing damage to the patient, and it will be distribution to the healthcare need person. It will be equally distributed to all the level of person. Means person, whether it is rich or the poor, person will be upper social position or the lower social position, upper economic status or the lower economic status. We all have to give the treatment in every aspect, and we should not consider this type of, means naturally distribution of justice to every person, rich to the poor. So first of all, there will be non-maleficence, duty to endeavor to do no harm. Second one, benefices, duty to do good as well as caring in nature. Respect to autonomy, duty to respect the human dignity, freedom and free choice of the individual, and more importantly to facilitate in every reasonable possible manner to making of such a free choice. We are not giving the so much medical knowledge to the patient that patient is not able to thinking that which treatment is better. But we should have to give autonomy of his choice. Whether treatment will be taken or not, it will be decided by the patient only. We can give such just options, whether the operation, whether the medical treatment. But we should always have the autonomy of the patient. Means patient's choice is most. We are not empowering over the patient's choice. We should have to give his or her autonomy. There is an equal share in the distribution of the healthcare, equality and priority to given to those who are in need in proportion to their need. Medical ethics, there will be conventional law of courtesy that is observed between the members of medical profession. Doctor behave with his colleague as he would have behaved with himself. Means in the consulting room, if there is a such medical student or another doctor that will be present, we have to take less charges against that medical student or the doctor, because it is our medical fraternity person. So we are not taking same charge as we are taking from the another patient. Okay, we have to give some respect to the medical student or the doctor also. Also, in the case of etiquette says that we should not criticize our another doctor member. Okay, if the person is coming from taking the treatment from the another doctor, and we are not commenting that this treatment will be this type of treatment will be given by that doctor, it is a good or bad, it is or any bad remarks of the other colleague, we should have to avoid it. What is the origin of medical ethics? That will be described first by the Charak's oath in the 7th century, then the Arthashastra of Kautilya in the 3rd to 5th century, Surat, which composed Surat Samhita 200 to 300 AD, and now founded in the 1933, there is the Medical Council of India. It formulated the modern code of medical law and the ethics in the India. The Indian Medical Council Act, there will be 1933 Act was repealed and the Act of 1956 was passed. What are the members of the Indian Medical Council? There is one member from each state. There is which will be nominated by the central government in the consult with the state government. Second, one member from each university, elected from among the member of medical faculty of the university by member of the Senate or the member of court of university. One member of each state in which state medical register is maintained. 7 members elected from among themselves by the person enrolled on any of the state medical register, and 8 members that will be nominated by the central government. Till the finalization of the national medical student, we all have to follow the Medical Council of India. So these are the Indian Medical Council, in which there are the one member from each state, one member from each university, one member of each state, means person occupying the state medical council, one member from this state, and the person that maintain the medical register, state medical register, we have to take the one person from that also. 7 members elected from among themselves by the person that is enrolled on the state medical register, and the 8 member that will be nominated by the central government. Among these members, there will be president, vice president, secretary, treasurer will be elected, and there will be some executive member is also present. So they have the taking the office, and on the board there will be president and the secretary as well as register. Means every work, whatever that will be application made, we have to make to the register. The secretary will oppose the various new activity, and it will be finalized by the president of the Indian Medical Council. There is a vice president, 20 executive member, and this will be nominated. They hold the office for the 5-year. President and the vice president are elected. There will be council also appoint a registrar who act as a secretary also, may also act as a treasurer. Sometimes there will be secretary and the register will be, treasurer will be post. Two posts are the different. The registrar will be looking for the day-to-day work. Executive committee consists of the president, vice president, and 7 to 10 members. The first schedule of the Act contains the recognized medical qualification granted by the university in India. The second schedule will be those granted will be outside the India. Means Indian Medical Council में पहला schedule India में जितनी भी medical college है, and they are providing the medical qualification. This will be recognized by the medical qualification, and this will be granted by the University of India. So this is the first schedule. Second schedule, there will be medical qualification, recognized medical qualification, that is those granted that is outside the India. And third will be the person who are college that are not enrolled in the first, it will be accommodated into the part 1 of the third schedule. That is those granted by the medical institute not included in the first schedule. Second schedule of the third part, it will be those granted outside India but not included in the second schedule. They appointed, the medical register will be maintain the medical practitioner. Register is known as Indian Medical Register, that contains the name of all persons enrolled in the state medical register. If any name of the person that is removed from the Indian Medical Register, it will be automatically removed from the state medical register also. So whatever the person that is getting the degree, they are involved, their name will be entered into the medical register of the State Medical Council, and they have provided with the unique number, and this unique number will be automatically added in the register of the Medical Council of India. Second one will be the medical education. Whatever the medical education that will be provided by the medical college, it will be proposed by the Medical Council of India. It prescribes the standard of the postgraduate medical education, advise university to maintain uniform standard for the PG medical education. That will be PG consists of the committee, consists of the 9 members. Prior approval of Indian Medical Council is necessary before starting any PG course. If mandatory regulations are not followed, then the qualification will not be recognized by the Indian Medical Council. The council will be appoint medical inspector. Who is the medical inspector? They are the medical doctor, teaching doctor that have a working as a professor and head, having the 5 years of experience, working experience about minimum 5 years. Council appoints a medical inspector to attend at any or all examination held by the University Institution of India for the purpose of recommend to central government recognition of medical qualification. In the case of medical inspector, there will be teaching experience will be minimum 10 years. So associate professor having the teaching experience will be 10 years. It will be automatically also act as a medical inspector. The inspector have to no power to interfere with the examination. The inspector report to the council on the adequacy of standard of medical education, including staff, equipment, accommodation, training, and other facilities that provided by the medical education necessary. The council forward a copy of report to the medical institute, and the copy means medical inspector is satisfied or not. Whatever his report, it is forwarded to the institution, and one copy forwarded to the university. One copy will be with the remark of university sent to the central government. If council is not satisfied with the standard, it can make a represent to the central government to withdraw the recognition of medical qualification of any university. After considering, central government may send it to the concerned state government for submitting any explanation regarding the deficiency of services of the institution. Third one, it is a recognition of foreign medical qualification. If Indian national obtain a foreign qualification which is not included into the part 2 of the third schedule, he can apply to the central government. Now candidate has to provide all the information regarding the syllabus, duration of the course of the study, and this is forwarded to the Indian Medical Council, which has a authority to enter into the negotiation with any of the medical council of the foreign authority and can recognize such foreign qualification on the reciprocal basis. The central government may by notification in the official gazette amend the part 2 of the third schedule so as to include such qualification therein. Fourth one will be the appeal against the disciplinary action. If the name of any person that is removed from the state medical register, it will be may appeal to the central government after exhausting all remedy in the State Medical Council Act. Recommend central government for amendment, change or introduction of any new rule, new regulation for the teaching, modality in teaching, training, examination, service in the teaching, training institute, whatever that it will be recommend the central government for application of such new changes. Warning notice, council may prescribe standard of the medical conduct and the ethics and the code of ethics for the medical practitioner. It can issue warning notice containing certain practices which are regarded as falling within the meaning term known as serious professional misconduct, also known as infamous conduct. State Medical Council, that is, it is known as medical teacher from the different university of the state elected by the teacher of the different medical institution, consists of the member elected by the registered medical practitioners, some member that will be nominated by the state government also. They function, it will be the maintenance of the first register. It appoints a registrar that keeps the register of the medical practitioner. Any person having any recognized medical qualification can get his or her name to be entered into the state medical register. The name, residence, qualification, date on which each qualification was granted of every person who is registered under this act are entered in the register on payment of prescribing various fees. After passing the qualifying examination, it is necessary to undergo a period of training before qualification was granted to him. First provisional registration is given, so they can practice medicine in the approved institution for the required period. Means after passing the third, second MBBS, you have provided will be the provisional registration number by the state medical register. Based on this registration number, you are doing the internship for the 1 year. After doing the internship, you have to provide such internship experience certificate as well as application, as well as certificate from the dean of the institution. It will be presented to the state medical council, and they give the final registration number to the doctor. And based on this registration number, this is the lifetime registration number. Based on this registration number, doctor can do his or her private practice. Disciplinary control, they have the power to remove the name of the medical practitioner permanently or for a specific period due to serious professional misconduct. Also authorized for the restoration of the name to be removed. The doctor's name is removed from for a temporary period, 2 months, 3 months, or sometimes 2 years. Then after the 2 years, that will be person's name should be re-entered into the medical register. Warning notice, also issue warning notice similar to the Indian Medical Council. So disciplinary functions of the state medical council is there that there will be, if there is a doctor, it is convicted, has done any crime and doctor is convicted in the court. Again, sometimes public may charge against the doctor, there will be complaint that will be lodged against the doctor, and sometimes doctor working in the institution, doctor working in the college, there will be official inquiry from the official person, official position of that institute or the college. They can file complaint against the doctor. So based on all this, it will be forwarded complaint to the registrar of the state medical council. If there is a case is not much dangerous, so this registrar will be forward, whatever the application that it will be forwarded to the president of the state medical council. If there is a case is not much serious and these are the tribal cases, the application will be rejected and doctor will be acquitted. Means there is no such harm to the doctor occur. If the president thinking that there will be some inquiry is necessary for the complaint that will be lodged by the so president will be forming the committee. So there will be special subcommittee will be forwarded. Doctor will be invited in the inquiry. There will be disciplinary committee that it will be now. If during the inquiry, if the doctor provides the satisfactory answer and the inquiry member is satisfying, the doctor's answer is helpful for the inquiry and there is no such harm against the doctor, then they can make the report that doctor should be acquitted. If there is a condition that a doctor is having done the serious crime, then sometimes suspended, doctor can be suspended, doctor's name can be removed, it is known as penal erasure. Doctor can appeal to the central government for against the such action of the state medical council. Erasure of the name, if the doctor's name from the register, it will be removed, it is known as penal erasure. Why there is a name of the doctor is removed? Sometimes there is a death of the registered practitioner occur and that's why name of the doctor is removed. Sometimes entries which are made in the error, as an error or as a result of some fraud that has been occurred. So based also on that, there is a name of the doctor is removed. So penal erasure, that will be due to serious professional misconduct, the name of doctor is removed from the medical register for the temporary or for the permanent period. If the name of doctor is removed permanently, then it is known as professional death sentence. Means doctor is not able to do his practice for a lifetime. So it is known as professional death sentence. It deprives the practitioner of all the privilege of the registered practitioner. Serious professional misconduct, it is also known as infamous conduct. It is also known as ethical misconduct. So any conduct of the doctor which might be regarded as the disgraceful as well as dishonorable, it involves the abuse of the medical profession. Serious professional misconduct, also known as infamous conduct, also known as ethical misconduct, also known as ethical negligence, also known as ethical malpractice. So these are the various names in which the doctor's conduct, doctor's behavior, it will be disgraceful as well as dishonorable. There is no punishment in the IPC or any other law. The only punishment will be given, that is will be by the MCI or the State Medical Council, in which there is a name of the doctor is removed. List of professional misconduct issued by the Indian Medical Council Act Regulation 2002 include many acts for which there are punishment both in the IPC as well as MCI. In the case of MCI, there will be ethical misconduct. In the case of IPC, there are criminal misconduct. Now, warning notice, in where it is applied, if anyone that will be found guilty of any of the following offence mentioned in the warning notice issued by the Medical Council of India, his name can be removed from the medical register. For example, sexual intercourse with the patient or the patient's relative. So, doctor doing the sexual intercourse with the patient or patient's relative, it may be amounting to the bad behavior. So, it may be doctors can be sued and there will be warning notice will be given to the doctor. So, first of all, adultery. Second one, improper conduct with the patient or with the members of the patient family. Third one will be the conviction by the court of law for offence involving moral turpitude, issuing a false certificate in connection with the sick benefit or insurance, passport, attendance in the court, public services. Whenever doctor issues false certificate, these many charges will be applied. Withholding information of the notifiable disease to the health authority. Performing or enabling unqualified person to perform abortion. Doctor is not doing abortion himself, but there will be appointing such unqualified person to do the such job. Prescribing steroid or the psychotropic drug when there is no such necessary, because whenever there is a application of this drug, there will be proper dose is necessary, and in the case of steroid, there will be chances it will be relapses occur. So there will be proper dose as well as tapering of the dose is required. If doctor is not followed, there will be damage to the patient also occur. Not displaying the registration number given to him in the clinic, prescription and the certificate issued by him. Dichotomy or the fee splitting means the doctor receiving or giving commission. Using of touts or the agent for the procuring patients. Disclosing secrets of the patient. We have to make the whatever the information that we are getting from the patient, we have to maintain such information will be secreted. Means it should be only between the doctor and the patient. It is known as professional secrecy. If doctor disclosing such secrets of the patient, that will be amounting to the known as warning notice. Covering, that will be assisting someone who has no medical qualification to attend, treat or perform an operation on some person. Write prescription in the private formula of which only he or pharmacy has a key of the answer. False advertising of his practice. There will be running an open shop for the sale of medicine for dispensing prescription of the other doctor. Drunk and disorderly, so interfere with the proper skill practice. Having involvement in the physical or the mental torture to other person. Doing sex determination test. Failure to obtain consent of both husband and wife in an operation which may result in sterility. Failure to obtain consent of the female patient, her husband and the donor in act of in vitro fertilization. Means whenever there is an operation that result involving the genital organ in which there is a complication of the operation will include the sterility. So in that case operation we have to take the consent of the patient as well as spouse. Consent is necessary, but doctor is not taking such that there will be a chance that he may suffer the charges of negligence as well as there will be action will be taken by the State Medical Council by known as warning notice. In the case of female patient, her husband and the donor, consent is necessary in vitro fertilization. But if doctor is not such taking consent, then there may be a chance that there will be facing the complication. And Indian Council of Medical Regulation, if doctor is not following such regulation, there will be a chance that he may face the warning notice. So to memorize, 6A is necessary. There will be adultery, alcohol, advertising, abortion, addiction, as well as association. Professional misconduct, these are the false photographs such comes with the sex clinic, and there will be consultation charge, lab test, injection, tablet. So this will be the various false advertising. There is a Kakkar sex clinic. These are the false. There is a professional misconduct photograph showing there is a canvassing using of touts or agent for the procuring patient. There is a second photograph showing the supplying or selling drugs of addiction, seducing a female patient. Means there is a person having another complaint but examining another part without the consent of the female patient. So that this is also this behavior. Attending patient while on the alcohol, issuing a false certificate, and there will be a dichotomy. Professional misconduct, taking this sparingly of a culling. There is I never thought that Dr. San is so poor in surgery. Your hand is not recovered even 5% after surgery. We should not take such complication. Means we have not authority to make any such bad comment about our colleague. Hippocratic oath that state that we had in the case when we are entering into the first MBBS, we are taking the Hippocratic oath. It is a declaration of Geneva that at the time of registration, applicant had been given the copy of such following declaration and should be under sign. I solemnly pledge myself to consecrate my life to the service of the humanity. I will maintain the utmost respect for the human life from the time of conception, even under threat. I will not use my medical knowledge contrary to the law of humanity. I will not permit consideration of religion, nationality, race, party politics, or the social standing between my duty and the patient. I will practice my profession with the conscience and the dignity. The health of my patient will be my first consideration. I will respect the secret which are confided in me. I will give the teachers the respect and the gratitude which is their due. I will maintain by all the means in my power the honor and the noble tradition of the medical profession. I will treat my colleague with all respect and the dignity. I shall abide the code of medical ethics as enumerated in the Indian Medical Council Regulation 2002. I make these promises will be solemnly, freely, and upon my honor. So these are regarding the medical law and ethics, first topic. Again, today we will also discuss regarding what are our duties of the medical practitioner. Hippocratic oath that we have discussed. So what is the ICMR regulation? The doctor shall not refer the patient for the consultation unless it is necessary. Without examining, doctor should not refer the patient. Physicians are free to choose their patient also, but shall not refuse the treatment. Should not neglect the patient. Doctor should not withdraw the case without giving any prior notice. Drugs that prescribed should explicitly state the appropriate formula and their generic name. Okay, we have to give the advise the drug that is should be a proper readable language. Okay, drugs that prescribed should explicitly state the proprietary formula and their generic name. Means in the case of Calpol, the Calpol it is a generic name. Calpol it is a trade name. It will be a main drug, it is a paracetamol. So we have to use paracetamol. Name should be mentioned as a paracetamol, tablet paracetamol. And again, alphabetical capital letter. Should not undertake any sex determination test. Should not subject their patient for the trial of any drugs or therapy without taking the consent. Should maintain the record of the indoor patient. If any request that is made for the record by the patient or their authorized agent or the legal authority, they should hand it over in the 72 hours. Should undergo at least 30 hours of continuing medical education CME program every 5 years. Every physician shall display the registration number in his clinic and the prescription paper or any certificate that will be issued by the means whatever we are issuing the certificate or we are issuing the prescription certificate, doctor's name, registration number, it should be maintained, it should be in every your paper in the one corner. Physicians should disseminate advice on the public health issue. For example, nowadays there is a coronavirus infection, pandemic is going on. So doctor can give the such health information necessary, which the patient has to take care, what taking care is necessary. Doctor can give advice to such advice in the case of specific issue. What are the rights of medical practitioner? First of all, medical practitioner has to right to practice medicine, right to choose a patient, right to dispense medicine, right to possess and supply dangerous drugs to the patient. We can know that this person having the serious disease and treatment of this disease will be the harmful drug, sometimes steroid drug, of the person having the cancer and the chemotherapy agent is necessary. So we are knowing that these are the harmful drugs, but we have the right that we have to apply these drugs to the specific treatment. Right to a title, description, etc. to the name, right to recovery for fee, right for appointment to the public in the local hospital, right to issue medical certificate, right to give evidence as an expert. Now, Red Cross emblem, according to Geneva Convention Act 1960 under Section 12, prohibit the use of Red Cross and other allied emblems such as Red Crescent, Red Line and the Sun for any purpose without approval of the Government of India. And Section 13 says, so Section 12 says that Red Cross, Red Crescent and the Red Line, we have no right to use because these are the only for the members of the Red Cross Society. We have no right to use of such symbol. If we are using, that will be, then Section 13 says that there will be penalty for the unauthorized use with a fine up to 500 rupees and forfeiture of the goods upon which emblem was that will be used. It is a right only for the members of the medical service of any army. What are the duties of the medical practitioner? We have to use a reasonable degree of skill and knowledge. Whatever we have our specialized qualification or basic qualification, then we have to apply the knowledge only on that based on your qualification. MBBS doctor is not have necessary to apply the knowledge of the surgery. Okay, but basic knowledge of skill have to apply. Once the patient admitted in the emergency or in case of accident, patient had a reasonable degree of care should be given. Doctor owe duty even when the patient treated free of charge. If neither doctor have neither guarantee cure nor an assured improvement. Duty with regard to the attendance and examination, doctor cannot withdraw from the patient without the consent, except whenever doctor becomes ill, patient is malingering. There is no such harm to the patient, but patient there will be acting like a malingering. Patient uses other remedy other than the prescribed. Patient ignore the instruction that given by him. Previous financial obligation are not fulfilled by the patient. Another doctor is also attending the patient, and patient persists the use of intoxicant or the poison. Duty to furnish proper and suitable medicine. Doctor should furnish the patient with the suitable medicine. Legible prescription is necessary. Doctor is held responsible for any temporary or the permanent damage in health due to wrong. Duty to give instruction, full instruction, means what is the dose and what time patient has to take. Also, we have to advise the patient regarding the adverse effect of the drug. So, every doctor has a necessary to give the all information regarding the treatment. Mention the quantity, time of taking of the medicine, also guide the patient regarding the adverse reaction and to stop the drug in case of reaction, and also approach the doctor immediately. Duty to control and the warn the patient of the danger involved in the use of prescribed drug. We have to also involve the, we are knowing that this drug is necessary, but we are also knowing that this drug has a specific, some complication also. So we have to apply, we have to give the complication, knowledge of side effect also to the patient. So patient can aware and not fear for the any side effect. Drug administration which might affect the patient's functional ability like a driving car, machinery operating, doctor should explain danger to the patient. For example, sedative drugs that is necessary. In the case of psychotropic, we have to give the information that this drug may cause some sleepy effect. Third party, if the patient is not able to take care himself or herself care, then we have to give such instruction to the patient's relative. duty towards the children and adults which are incapable of taking care of themselves, then third party should be having the basic knowledge is necessary. If the treatment or operation contemplated carries special risks which are known to the doctor but probably not known to the patient, the doctor should inform the patient of this risk and obtain his consent. Duty with regard to the poison means the doctor has to handle the poison carefully. Each poison should be kept in the separate bottle. Labeling of the poison is necessary. If the person is taking such poison, then the immediate treatment is necessary. And poisoning, it is a medical legal case. So we have to assist the police in the determining whether the poisoning is accidental, suicidal or the homicidal. Notify certain disease. So communicable disease, there is a smallpox, chickenpox, cholera, plague, typhoid, measles, diphtheria, yellow fever, food poisoning, swine flu, and nowadays there will be coronavirus epidemic. So this, every single case has to be informed to the health authority, and it is known as notification of that disease. So by giving information to such health authority, they can apply some preventable measure. They can apply to the strict measure to prevent the spread of disease in the community. Also give bound to information regarding the birth, death. There will be, if a doctor fails to conform to the statutory or administrative requirement, he will be liable for criminal penalty as well as negligence.
Online
Duty with regard to the operation, doctor should explain the nature and the extent of operation and take consent of the patient. Every operation will require the separate consent. Proper care to avoid mistakes. Surgeon must not delegate duty to the another. He must not experiment. He must be well informed of the current standard practice and must follow it. Operate with proper and the sterilized instrument. Make sure that all swab and instrument that will be used during the operation, it should be properly removed. He should take proper post-operative care also. So these are the basic concepts regarding duty with the operation. Under Geneva Convention, any member, any person of the first convention, armed forces, second convention will be shipwreck, third will be the prisoner of the war, fourth convention will be civilian of the enemy nationality. Whenever patient of this four convention, we have no right to refuse the treatment of such person. We have to treat the patient based, without any adverse distinction based on sex, race, nationality, political oppression or any. Regarding the consultation, the consultation of the senior doctor is necessary. When it is necessary, when the patient is himself requesting the doctor. In case of emergency, when the case has taken the obscure turn, its quality of care or management can be enhanced when the specific treatment involving danger to the life, when the operation affecting the vitality of intellectual function, when operation performed on the patient who has received serious injury in the case of criminal assault, in case of homicidal poisoning, when a therapeutic abortion is to be procured, woman having criminal abortion sought advice for the treatment in which there is the consultation of the senior doctor is necessary. In the case of connection, X-ray examination, whenever necessary, all cases of accident should, unless they are very minor, it should be properly X-ray. Wrong interpretation of X-ray, sometimes help will be negligence. In case of criminal cases, under section 176 IPC and the section 39 CRPC, doctor is bound to inform the nearest magistrate or the police officer whenever there is a commission of crime like the murder, ducate, escape of the prisoner occur. Under section 202 IPC, there is a person is treating by the doctor and intentionally omit to inform the such cases, then the doctor will be punished with the imprisonment up to 6 months. Doctor is not too bound to inform the cases of attempting suicide, but he has to inform the homicidal cases. In the case of emergency, doctor has a moral, ethical and the humanitarian duty to do his best to help the patient in the saving his life. In medical legal injury cases, doctor is obliged to give necessary medical and to save the life of the patient and render all help to refer the further institution as early as profession. Now, what is the professional secrecy? It is a term of contract between the doctor and the patient. Means whatever we are getting the information from the patient, it should be properly, such information should be properly, doctor has to keep the secret. So, All that comes to it is a disclosure will be failure of trust and the confidence. Patient can sue a doctor for damage if the disclosure is voluntary, has resulted in harm to the patient and is not in the interest of the public. Doctor should not discuss illness of the patient with other without the consent. If the patient is major, doctor should not disclose fact about his illness to his or patient, though they pay the fee. Should not answer any inquiry made by the third person. In case of husband and wife, fact relating to the nature of illness of one, if not affecting to the other, then don't disclose without the consent of the concerned person. In divorce and nullity cases, no such information without the consent. Except notifiable disease. If the disease is communicable, then we said to have to break the secrecy and we have to inform to the health authority or the another will public. Domestic servant examine at the request of the master, though the master pays the fee, but information that is given by the domestic servant, it should not be forwarded to the master. Same is applicable to the government servant, same is applicable to the former factory employee. Means though employer giving the fee for the examination of his employee, but whatever the information that we are getting from the employee, we should not pass such information to the employer. Medical officer of the government service also maintain the secrecy, even the patient is treated free of charge. Prisoner of under trial, they have no such right. The doctor has to examine and doctor has to disclose the nature of illness to the any person. If person is convicted, again prisoner and the convicted person has no such right and doctor has to give all information to the authority. Life insurance policy, whenever there is examination is made, finding also not disclosed to the insurance company without the consent. When the case is reported in the journal, we have to maintain the identity also. In the case of autopsy examination, certain fact that will be founded, it should not be disclosed to the patient's relative that may affect the mentality of the relative. Opposite to the professional secrecy, it is a privileged communication. So it is a statement made bona fide upon any subject that is meted by the doctor to the concerned authority due to his duty to protect the interest of the community or of the state, to be privileged communication made to a person having interest in it. If the doctor discloses professional secret for the purpose of protecting the interest of the community, he will not be liable to the damage. So, for example, some infectious disease, communicable disease, so whatever the person is suffering, he should have to inform the health authority to prevent the spread of disease in the community. So employee as a cook, waiter in the hotel, food handler having entering infection, teacher with the tuberculosis, it should be informed. Servants and the employee, engine driver, bus driver or the ship officer suffering from the high blood pressure, epilepsy, alcoholism, drug addiction, it's all should be person having such disease, it should be informed to the authority. Because during person is suffering from such disease, there may be a damage to the other person also. Venereal disease, same. Person suffering from syphilis and is about to marry, advise that not to marry until he cure. If the patient refuses, doctor disclose condition to the woman concerned. Notifiable disease, doctor has to notify birth, death, infectious disease to the health authority, suspected crime. Under section 39 CRPC, magistrate should be informed whenever there is a crime has been. Self-interest in the civil and the criminal suit made by the patient against the doctor, evidence regarding the patient condition can be given in the court also. Patient's own interest, sometimes suicidal tendency, then we have to give the such information to the close relative to prevent the sometimes court of law asking the doctor to provide such information, we have to give the such information of the patient. Sometimes patient also has the right, he should furnish the doctor with the complete information about the policy. Duty means whatever the patient getting the treatment, patient has to give the past history, medical history, any allergic history, any family history, all history, medical history has to be given to the doctor. He should strictly follow the instruction of the doctor. He should pay reasonable fee to the doctor. Privilege and the right of the patient. The patient has a choice to choose the doctor freely. Every access healthcare facility available regardless. Dignity, patient has to be treated with the dignity, with the care. It should be treated in the privacy during consultation. All information that we are getting from the patient, it should be confidentiality should be maintained, and we have to receive full information regarding his diagnosis, investigation, treatment plan. Safety, whatever the patient has a condition, we have to give such information as well as what procedure are applied, diagnostic, therapeutic modality, complication, side effect, expected result, whatever the disease has a specific information, we all have to give information such to the patient. Right to know about day-to-day, patient has a right to that how much my disease is cured, right to consent or the refuse any specific measure, second opinion whenever there is a necessary, access to his record and the demand summary, to receive continuous care of his illness from the physician, to be treated in comfort during illness, right to complain if any, the compensation for medical injury or the negligence against the doctor. Physician-patient relationship, it is a therapeutic relationship in which doctor is free to accept or refuse to treat the patient. Doctor may refuse to treat the patient when there will be beyond practicing hour, not belonging to the specialty, illness beyond the qualification, doctor is unwell, doctor having important social function. So doctor has a specific some rights also. Based on his or her right, he can withdraw the patient also. Doctor, patient defaulting in the payment, patient uncooperative, malingering, patient refuses to give the consent, patient demanding some drugs, amphetamine or athletic, patient rejecting low-cost remedy, and at night on ground of security. Formal relationship means in the case of medical-legal cases examination, patient can be bring by the police, and we have to treat the, we have to make the report. For example, medical-legal report, injury report, alcohol report. There will be post-mortem, sometimes potencies report. There will be poisoning report. So whatever we are getting the information and we are making report on the requisition of the police. So there is a relationship between the attending doctor and the patient is established. It is known as formal relationship. There is no such therapeutic relationship is applied. So in the case of mostly medical-legal cases, there is a formal relationship is applied. So these are all basic regarding the duties of the medical practitioner and the duties of the right. Thank you.